Welcome to the Cresco Wealthcast. My name is Dimitri Korolis. I'm the host of the pod, and I'm also an advisor within the Cresco Wealth Management team. Just want to say a quick thank you to all of you that continue to support and follow the channel. I appreciate you, and of course, welcome back. And if this is your first time to the podcast, thanks for stopping by, and I hope you enjoy. At the Cresco Wealthcast, the inspiration was very simple. I wanted to bring topics that were derived from real conversations, and I wanted to do it in a way that was relevant and relatable to you. And a lot of the conversations and the content that you're going to hear, it's coming from clients, it's family, it's friends, it's just being out and about and having those real conversations. Nonetheless, I hope you enjoy, but before I let you go, just want to let you know you can find us on LinkedIn, Facebook, Instagram, and YouTube. Just search at Cresco Wealth Management. Till then, enjoy the pod. Oh, and by the way, that music you're hearing, that's Pete Ems. He's one half of Small Town DJs, and it was nominated for a Juno Award. He's on the team, no big deal. All right, we're back with the Cresco Wealthcast. Thank you for joining us. Really exciting episode today. It's going to be a lot of fun content, but also the backstory behind it. So first and foremost, I want to introduce Abram Averbach from Scott Venturo Rudicoff Lawyers. Thanks for joining us today.
Thanks so much for having me. I'm really happy to be here, guys.
Yeah, it's going to be exciting. And then alongside, some of you have come to know through the podcast, Senior Financial Planner. I say the brains of the operation at Cresco Wealth Management. I've yet to be challenged on that, but Wayne DeBoer in the house.
Thanks, Dimitri. Good to be back.
I know. So we have to paint the picture here of what's happening. And this is just a great reminder that Calgary is a village, no matter how big Calgary gets. So Abram, we're on the 16th floor, you're on the 15th floor. We've almost been like terrible neighbors where we know we exist, but we'll never say hi. But we just have to be there in case we need to borrow a bag of flour or something. But, and then we realized as we were talking, even personally, we have, between the three of us here, friends. So this is amazing. Yeah, like I said, be kind to everyone. You never know who you run into in Calgary. It's still a village. But we brought you in for your expertise today. You're gonna be talking to us about family law. But what was exciting is when we first started really doing the ideas for the podcast, you of course brought to our attention how vast it could be. So we do plan to do a series of these episodes, get them targeted. I can't wait. But I'll turn it over to yourself, Wayne, to kick things off and get things started with us.
Yeah, thanks, Dimitri, and welcome, Abram, to the podcast here. It's great to have you.
Thanks so much.
Thanks. Gratefully, you could make the journey up the floor, and but yeah, just to kick things off here today, when we talk about family law, there's obviously lots that goes on. Sometimes there's good stuff, sometimes there's bad stuff, and I'm glad. I think you said to us before, we get to talk about the happy side of family law. But before we jump into that, I was thinking it might be helpful if we have some common language for when we talk about things. And there was a few terms I was hoping maybe you could define for us here, Abram. So the first one is really family property. So in the context of family law, what is family property?
Yeah, thanks, Wayne. And again, I'm really excited to be here and to share this. As I was saying to you guys, this is an area of family law I love talking about. And so to answer your question, when we're talking about family property, we're really talking about a vast amount of property. It's going to apply to both married and unmarried people. And I think that we can put things into, generally speaking, two buckets. There's the bucket of things that will be divided upon a separation. Now that's going to be the things that are acquired during the relationship, and that being either a marriage or in an unmarried scenario after two people have lived together for 3 years. And important to know is that once that 3-year threshold is captured or is crossed, under the Family Property Act, retroactive back to day one is where we start the analysis of property accumulated. So family property refers to that. It's the stuff that people would think of as our matrimonial property, as the things that we've acquired during our relationship. In most cases, that type of property will be divided in half on a separation. The other bucket, I'll call it, of property is the property that's exempt from a division. And that's really what I want us to be talking about, or what I'm excited to talk about today. It's the property that isn't subject to that division on separation. And there are a number of things that fall into this. I think relevant for our discussion today, inheritances, and gifts from third parties to just one of the people in the relationship are things that fall into this category of exempt property. As we go forward in our discussion, treatment matters under the law. What happens with that property, that exempt property after it's received, is entirely impactful to maintaining its exempt status. But largely speaking, when we're talking about family property, we're talking about the types of property that are divided, and it's everything. It's houses, it's bank accounts, it's debt, it's vehicles, investment accounts, anything of that nature. And then depending on how and when that property is acquired, it's either divisible or it's not in the event of separation.
Okay, great. So we've got family property and exempt property. Some is divisible, some is not divisible. That's kind of my interpretation of that. So that's kind of where we'll start with that. And then another definition that I think is really important. Who's a partner? Like when we talk about who I'm dividing property with, how do we define that? It's like, I know over the years that I've been, in the industry, sometimes common law meant something different than being married, and that's sort of changed and evolved over time. And in Alberta, we have another type of partnership called an adult interdependent partner. So can you sort of walk us through who a partner is when we're talking about family law?
Well, it depends, but in the context
as every good lawyer says, right?
Yeah. Leave enough gray to wiggle out of it in the end. It depends. In the context of property division, really what we're looking at is the Family Property Act, and so what happened in 2020 when the Family Property Act replaced the Matrimonial Property Act is that some of these terms gained some clarity. Common law, what that meant, how property division was approached. All of that changed, and certainly from the family lawyer's perspective, it became a lot more clear-cut. We had no legislation dealing with property rights for unmarried people prior to the conversion of the Matrimonial Property Act into the Family Property Act. So from that property law perspective, if you're married, you're certainly partners who are going to be subject to property division under the Family Property Act. And once you've lived together for those 3 years, you are now under it. And interestingly, living together is sometimes fungible. There is case law where the courts have found that maintaining 2 residences doesn't mean that you live together, or doesn't mean that you don't live together. And so there is a wide definition, but I think generally speaking, once you start seeing that commitment and that bringing together of 2 lives into one, you start getting into this definition. But the 3 years for unmarried people is absolutely material. If a relationship where 2 people are living together ends before that 3 years, there are no property division. Now, you might have adult interdependent partnership obligations from support perspectives and those sorts of things, but the acquisition of rights under the Family Property Act requires that 3-year threshold unless there's an agreement that accelerates that timeline.
That's a great segue into my next question about definition. I think this is the last one I have, unless Dimitri, you have a couple words. What is an agreement? We sometimes talk about different types, like these family law related agreements. I imagine through our conversation today we'll use some terms interchangeably, but what are some of those agreements that we're referring to when we say things like family law agreement?
A cohabitation agreement, for example.
Exactly. What's covered under that umbrella?
Yeah, so under that umbrella of agreement, from a property perspective, we're looking at cohabitation agreements. Cohabitation agreements are the types of agreements that are really intended to apply to 2 people who are living together in an intimate relationship who aren't married. Then as we get closer to the wedding, perhaps we enter into a prenuptial agreement. So a prenuptial agreement is with the contemplation of marriage, and it's intended to cross into the marriage. And then we can have another type of property agreement that is called a marriage agreement. And that can be after the marriage has happened. We can still go in and address the way that a family wants to deal with their property in an orderly manner in the event of separation after marriage. Now you have different considerations during each of those agreements, but those are largely the property types of agreements. We can also have spousal support agreements as a standalone agreement that defines what spousal support or partner support might look like in the event of separation. That can be rolled into any of these other agreements, or it can stand alone. And when we're talking about these types of agreements, it's not an all or nothing type of scenario. Perhaps there is a single asset that a family wishes to deal with in an agreement of this nature. We can do that, and then the rest of the property would be dealt with in accordance with the Family Property Act. So it doesn't have to be everything. It can be really surgically defined, or it can be much more broad than that.
Does one, with those different types of agreements, from cohabitation to prenuptial to marriage, does one negate the other as you go through that process? If we have a marriage agreement, anything from those agreements prior are now off the table?
Yes and no. Typically, what you would do in these agreements is it's sort of an update in time. And so perhaps in the cohabitation agreement, we're talking about the $100 of pre-relationship property that I brought in. Well, and we've protected it. Perhaps by the time we're talking about a prenuptial agreement, that $100 is now increased to $200. And so we're just capturing these new values. Perhaps we're changing them. And so I think that the answer is yes, it would negate, but more often what we're doing is we're standing it on top of the pre-existing obligations and building forward as this family looks at their lives much differently as the relationship continues to gain more longevity and more permanence.
So it'd be a good idea to revisit the contents of what we've done before and make sure that they're updated accordingly.
Dimitri, I appreciate you. Yes.
Yeah, gotcha.
Yes, it is.
Yeah, that's the wink. Everyone, listen again. It would be very much suggested to revisit the contents. Thanks, I appreciate it. Yeah.
So I guess that being said, are there any other things that we need to know from like a foundational standpoint before we launch into this, Abe? Like, anything else from a, I don't know, I hate to call it family law 101 standpoint that's important to know before we talk about wealth transfer? What are your thoughts on that?
Yes, and I want to sort of set the table for that discussion and talk about why I like talking about these types of agreements, especially in the context of intergenerational wealth planning, succession planning, parents thinking about how and when they're going to gift to their children and their grandchildren. One of the reasons I like to do that is because in my line of work, this is the happy side. This is where we're not dealing with a separation. We're dealing with families who are looking to really make differences in the next generation's standard of living and comforts and all of those things. And so family law agreements can play a really important role in that intergenerational wealth planning, because what we can provide in these agreements is flexibility. Because nobody's looking to transfer assets to the next generation to have them just sit there. Parents are looking to transfer assets so that their children and their grandchildren, and in some cases beyond those generations, can use them and enjoy them. What family law agreements can do is help ensure that while that is happening and while we are protecting the wealth that's created at what I call the first generation level is protected in the event of a separation at the next generation level. but in a way that we navigate away from the strict operation of the law, because the strict operation of the law will have some prejudice built into it to that wealth if the next generation is not using it really, really carefully. So what these agreements can do is actually add to the enjoyment of the wealth transfer as opposed to subtracting it from it, all the while protecting it. So to come back to your question, yes, the answer is we should talk about some of those, these foundational concepts. And when we were talking about property, we were talking about specifically gifts and inheritances. So if a parent passes away and leaves an inheritance to their child, under the Family Property Act, that inheritance is what's called exempt. It is protected from a division in the event of separation. So are gifts from third parties to just one of the second generation spouses. So where you have a situation where parents are looking to do things like a living will or something where, you know, there's this nouveau concept that I wish didn't exist, but which is, or wasn't nouveau, where parents are wanting to see the fruits of their labor from an intergenerational wealth standpoint used. They gain enjoyment from that. We don't need to wait until there's a passing to, you know, give that gift to really buoy the next generation and as they move forward. So those gifts, insofar as they come from a third party to just one of the spouses in the next generation, are exempt, as are inheritances. But the treatment of the matter under the law. So what the family lawyer would say when someone receives an inheritance, and we're talking about an inheritance in the absence of any agreement, is take that money, put it into an account that is in your sole name, and never let it come out of your sole name. That's the way this exemption is crystallized and perfected. So under the Family Property Act, we need to have that exempt event happening. We need to be able to point to the money still existing. And if it goes into joint names, there is a prejudice to the exemption. So from a protection standpoint, the best thing that you can do with exempt property outside of a family law agreement or in the absence of it is nothing. And that's not the plan here. That's not the intent, and that's not why everyone's worked so hard to get here.
And sorry to interrupt here, but sometimes too, like what I've heard in my, you know, experiences has been even just watching how you use the income from that account. So if I receive something from my parents, I put it in an account, there's $100 there. People have said to me in the past, don't even use the income from that to support your family, because or else you jeopardize keeping that, because it's subsidizing the lifestyle your family's gotten used to. Is there truth to that side of it as well?
And again into the gray, there could be. Yes, there could. So where exempt property is being used to support the lifestyle, there's oftentimes then seen as an intention to take something that was otherwise exempt and bring it into the joint family property type of framework. Now, if you're talking only about income being generated and not touching the initial capital, we might have something different to talk about. But when it comes to exempt property, while that $100 inheritance on day one is exempt, if it is invested and it grows, now that growth is going to be shared on a just and equitable basis. And there are a number of contextual and factual considerations as to what is joint and equitable in that type of situation. But presumptively, I think you look at this and you say, well, we figure it's going to be 50-50 on that growth. So these are all the types of things that in the context of these agreements we can work around. Now, one of the great things that family law agreements do is that they help a family look towards what could be an eventuality that nobody wants, but at a time when nobody is in it. And so everyone is still the best versions of themselves. The concept of fair, I always joke, it's true on its numbers, but fair is a 4-letter word when it comes to family law. Fair is subjective. But what you feel is fair before a relationship ends might be very different than what you feel is fair after a relationship ends. And one of the most important things that I think family lawyers can do is help people be the best versions of themselves when they are in a situation that they can't be the best versions of themselves. So that person who during the relationship has defined fair is probably closer to who you want to be and who you really are than the person who is unfortunately now hurt because a serious relationship has now ended. What we can do also in our family law agreements is work around some of those operations of law. So like I said, if exempt property is put into joint names, half of the exemption is lost. For our discussion today, let's say the other half is divided equally. So by putting the $100 into joint names, $50 of it remains exempt, and the other $50 is divided equally between the parties. So just by that move, the inheritance goes onto the mortgage, or the inheritance goes into down payment on a new home. Just by that step, the $100 has now turned into $75 because of that action. Well, we can draft around that. So this is what I'm talking about when I say we can enhance flexibility. We can have contractual provisions that say that action does not prejudice the exemption. So now all of a sudden, money that has been intergenerationally passed stays within the family that has done that gift or that inheritance, but it's being used to really benefit the family at the next generation. Similarly, when we talked about the family lawyer saying, put the money in a bank account and don't touch it, that's because we need to see tangible remaining property out of that exemption. Now it can change. The $100 exemption can be used to buy a vehicle. I'm not sure exactly what years we're talking about with that vehicle, but the vehicle would then remain exempt, and that's a concept that we refer to as tracing, so you can follow the money. Well, if the intention is at that second generation level to not require that, then we can draft around that. We can say, if you can show that some of this gifted or inherited property has been used for the benefit of the family, it doesn't matter. You're going to get all, or you're going to get some of that back. Or when we think about things like renovations, maybe a family is doing a material renovation on their house. Now, renovation and how renovation communicates with value created is not always dollar for dollar. Well, we can plan for that in an agreement, and we can say if $25,000 is used towards a renovation, that creates a $25,000 exemption in the home. So this is where we're adding this flexibility. And we can, and sorry, go ahead.
Yeah, no, I was saying what I like and what I'm getting out of this too is a really good point that a lot of industries deal with it, whether it's ourselves here. When things happen, then we have to get educated and up to speed. And then we say, well, that doesn't make sense, or I don't like that. And what I like hearing from you is a lot of this preemptive, why we're doing the podcast or why someone should have these conversations beforehand. Like the fair is fair today, but might not be fair tomorrow, or just the education around what you're saying. This is why confronting and addressing these things today is so important. I just wanted to reiterate that point in a break here is, instead of getting to a point where we have to get educated and then add more animosity because the outcome might not be favorable, these are some really good things and areas to look at.
Well, and it sets the expectations.
Yeah.
And it also navigates away from an outcome where, let's say both people have received inheritances, but one has kept it in their bank account and the other hasn't. Now, we've got someone who's got a perfected exemption at the end of a relationship, and the other who might not have any exemption left. And so while both of them thought that they were keeping something, they might not be keeping it anymore.
Wow. Yeah. There you go. Yeah. Wow.
And it's part of a layered and sort of globalized strategic approach to family planning from generations. I'm not going to do your tax side of things because I'm not smart enough. I'm not going to handle your investment management because that's what you guys do. But what we can do then is also add this other side where mom and dad don't have to be afraid of what can happen with the wealth that they have worked their lives to create if there is an unfortunate separation at their children's level or even below that.
Are you finding that causes a lot of inaction in your world as well, that they either don't know the outcome or they haven't set up the outcome, and then you see it creates families not doing anything at all because they have that notion or preconceived notion that it should go this way, I'll hold on to it, or I'll do all of these things on my end because I feel like I'm protecting, when maybe it's a headwind and they don't realize?
Yeah, I find that I find that the most common type of family who is not live to this are not the really, really high net worth families, because those families already have the planners and somebody's live to this. This flexibility through the agreements, I don't think gets enough consideration. And that's why I keep banging on this door anytime there's a door for me. But the families who I think are not live enough to this are, call it your typical baby boomer generation who has amassed a really good portfolio and a really good, family of net worth. But they're just not thinking about this. And this educational component of the how and the why, because generally speaking, at the children level, the child and their spouse, that spouse, and again, in the Fair is Fair Today example, that spouse, the non-biologically related spouse, doesn't want to touch any of this money. They understand how it was created and where it was created. And so they're looking at it from a fair perspective also and saying, this is your parents have created this wealth. Yes, I think it will be great if we can buy that recreational property, if we can finally, renovate our kitchen or any of these things and make use of the money. But I don't want that. No matter what happens, I don't want to come after that money. And so the families that I think are perhaps most exposed to inaction or ignorance in the least pejorative sense of the word possible are the quote unquote normal families, where there's going to be an inheritance of, and perhaps normal is not the right word, but a family where there is a sizable but not vast inheritance that will be coming to all or some of the children. And I think those are the families who are sometimes underserviced in the receipt of this information, because they may not have the same level of resources around them at all times.
Fair. Yeah. Well said. Thank you.
Like hearing you say that, it actually it makes me start to think that agreements like this could actually, sorry, I'm going to back up just a half a step here. Sometimes when we talk about family law agreements, they are, thought of negatively, because you think we're going to split? Don't you have confidence in our relationship? And then so people just don't have the conversation around it. And so it's like that fear of what that does in that relationship, the conversation stops them from acting on it. But then if you fast forward to that, then someone receives that inheritance, especially in like a high net worth family situation, maybe not the ultra high net worth, if where it's $50 million family situation.
To be clear, we can help in those situations.
Absolutely,
also, Wayne.
Absolutely. But going back to your example, some people who, they're in that high net worth range. So now they make a gift to their children. and because they've gone through financial planning or a wealth planning process, they've identified surplus assets, they said, I'd like to do something with this. They make the gift to their child, but now the child sits on it because they say, I've heard I can't do anything with it. And their spouse is sitting there saying, oh, we've wanted to do these things. Well, these agreements free up that relationship actually, because you can take away that layer of fear of what happens and then focus on enjoying it, focus on doing, like, perfecting the parent's actual gift, which was to make their child and their grandchildren's lives easier. I sometimes use the example with clients. A woman one time took a bequest out of her will for a church and told the church that they weren't getting $10,000 for her estate anymore. And they said, well, what did we do? Did we do something to make you angry? And she said, no, not at all. I know you want to buy a piano, so I'm giving you the check now because then I can hear the music being played. And so what these types of agreements do is they let the child buy the piano, but it doesn't just sit in the front room and doesn't get played because they're worried someone's going to scratch it. Yeah. Now they can see how that wealth impacts their children, their grandchildren, and so on and so forth. So I love the idea of this because it takes away that fear. And sometimes fear paralyzes us, and this is a good reason to not act from a position of fear. So I guess on these agreements, like, you're converting me to this thinking here, Abe, but when do you enter into them? Like at what point, what's the impetus to start the conversation around having one of these agreements?
Well, and to circle back to what you just said, I think you've hit the nail entirely on the head. And these are not comfortable discussions. They're adult discussions, they're real discussions, and none of us want to be having these discussions. Absolutely not. They're difficult, but I think you made exactly the right point, which is, with or without an agreement, I can protect this. Now, what this agreement does is allow me to protect it while it's benefiting us. I think you hit the nail absolutely on the head. So the when of these is really contextual. When a generation one is really starting to look at finalizing some of those gifts in life, some of those living wills, if we call them that, or just gifts to the next generation, that's the time to start protecting it. When there is going to be this, call it a liquidity event, that is going to positively impact the next generation's standard of living, that's when we want to start having this. That's when we want to start protecting it. For families that are at that generation 2 level, looking at marriages upcoming, that's when we're going to want to have a prenuptial agreement. Now, we can plan for this. It doesn't have to be at the last moment. There's nothing wrong with an agreement that says Wayne expects to receive an inheritance of materiality. And we might put in the numbers or we might not. Generally, we would prefer to put the numbers in because that ensures that the parties have the same expectations. Your definition of materiality might be different than mine. And whether or not it's true when someone's arguing that they didn't understand it in the event of separation stops mattering. If someone's saying, well, I understood, I thought materiality meant 1 million. I didn't know it meant 10 million. Whether or not that's true doesn't matter. Once you're into that fight, we've got a problem. So if we can quantify, generally speaking, from a conservative perspective, how much that inheritance could or may be, with an express understanding that it might continue to grow, we're adding some protections into the agreement. But we can define some of these rules that we've been talking about today even before it's becoming real. And we're setting out those expectations, and we're saying that the non-biological spouse understands, or partner understands, that this money is going to improve their standard of living beyond what their respective incomes can generate. They understand that this might lead to the acquisition of property. And and continue to draft around those. So I think that the time, if you're going to ask me, is now. It's always now. If you're turning your mind to this and how we can ensure that these intergenerational wealth transfers, which are being planned from tax perspectives, if we're looking at insurance policies, looking at any ways to mitigate tax on death, for example, once we start having those succession planning discussions, that's the time to engage family lawyers, because at that point in time we can really be crafting things proactively and in a way when we don't have concerns. We haven't done something that maybe is prejudiced and now we're trying to claw back something that's already been cost, or at a time when a family's going through grief, or anything like that. And so it's really at that succession planning stage. Once this happens, once we start those discussions, that's the time to engage, and let these types of agreements really fortify the intents of the parents.
Yeah, to interject here, listening to this, the first thing that comes to mind, and probably for a later podcast and maybe a little more dedicated, is maybe then there's a misconception about always having to create a family trust when you can actually look at addressing the issues of inheritance transfers through these, I don't want to say contracts, but through family law. And to say is that, maybe you'll give me the smirk for saying this, but family law would have the stigma of being, well, it's only about separations only, whereas I feel like what we're getting at today is, let's look at it from an asset base first that has components of generational transfer, perhaps separation agreements. So, the proverbial mind blown comment, but I'm thinking trusts, wills, if you're coming back, we probably have to do dedicated podcasts for these as well.
I won't say no.
Because then, that I just get the rabbit hole. My mind is just going and saying, yeah, well, someone comes to us and says, you know what, I want to transfer assets, or here's what we're looking at. Can I get in with a trust lawyer? Well, maybe that's not the only solution. Mm-hmm. Fair to say?
Yes, and so the family trust, and this will be another podcast of ours. I would love to come back and do that. The family trust does certain things. The family trust, from a family law perspective, is not as bulletproof as it seems. And so one consideration when we're looking at, I think we start looking at this and saying, well, is the juice still there? Is the juice worth the squeeze still in a family trust? Which it may be. But if those tax benefits have been shrunk by changes in our tax laws, well, then maybe we're looking at another way to accomplish the same goal. Because a family trust alone will not, in and of itself, protect from that second generation property division. If that trust is being used to support the lifestyle of the second generation, then the beneficial interest of that biological child is subject to attack. And so we might still need these agreements even where we have a family trust. But that also doubles into, I think, the last area where these agreements can be so impactful. And I said right at the beginning, it doesn't have to be all or nothing. So maybe we're only dealing with the family trust in a marriage agreement or a prenup or a cohab. And we're saying Sally or Susan or Johnny or whoever it is a beneficiary under this family trust. And that might be the only asset that we're dealing with, and we're referring to it the same way. Now, the rest of the family property at the child level is subject to the operation of the law, but we can still protect that asset. We can treat different things differently based on what the intentions are. Maybe the idea under an agreement is to say everything is separate. Everything that I've received as an inheritance is separate unless the following things happen. Maybe that family says, look, I've received this good size inheritance. I'm going to keep it separate. We understand that. But if I take something from the inherited separate property and put it into joint names, that represents an action by me that I'm comfortable with that says I've now brought it into the shared property framework, because that's the other side of the fair is fair. I know I just got $5 million or $10 million on an inheritance, and my partner hasn't. Well, I don't want that to be an inequity in our relationship. So if I take $1 million and we put that into the down payment on our house, and we're able to buy this fantastic family home, I know that when I do that, and I want that to be an action, and now you control the levers of that, where you're saying, I'm bringing this in on purpose, but I'm bringing it in on purpose at our choosing, at our time.
Very impactful.
Because some risks are worth taking, right?
Yeah.
So, and so I guess I just have, one last maybe quick question on like just a practical way, because again, sitting down with families, they identify surplus wealth. Right now it's really practical in the sense that like housing's unaffordable for a lot of people, and a lot of parents are looking at that and saying, how can I help my child, get into real estate? But they maybe don't want to say, hey, son, hey, daughter, have a conversation with your partner about this relationship agreement. Are there ways that parents or family members can protect gifts sort of on a unilateral basis? Like, for example, sometimes we talk about mortgages, promissory notes, things like that. Do those work in these situations if they say, I want to help, but I don't really want to stick my toes in the pool of their relationship dynamic? I don't want to impose that conversation on them. Are there other ways that a parent or a family member can help while still protecting that?
Yes. So the gift from the third party to just one of the partners creates that exempt gift. So first and foremost is making sure that's clear. Okay, so a card that is made out to your child that says happy birthday, or for no reason at all, I wanted to give you this gift, and this is we just wanted to share some of the wealth that mom and dad or whatever's the circumstance have created, and this is to you. Okay, so now we've established something that the family lawyers can look at the time of separation and say, okay, well, this looks like a gift to just one of them. When we're talking about debt instruments, that can also work. The debt needs to be serviced at least some way. If it's just, I think if you have a demand note, for example, demand promissory note, now if that's created at the time of the gift, that's going to be a strong indication of validity. Sometimes what we have are promissory notes that come out of the woodwork.
Post-dated.
Right. But if there's servicing of that debt instrument, that's really helpful. But again, the debtors matter. And so if the gift is, let's just say $1,000, and there's a demand promissory note, and the recipient of the gift is the only borrower on that promissory note, we've now got a really good closed loop to establish that not only as, well, it's not a gift anymore, but we've established that there is a debt paper trail there. Mm-hmm. And so that's important. But without the agreement, we're now into the next consideration of, well, the use matters. And so where you get a little bit of protection is that if that $1,000 is then put into joint names, well, that debt is probably now going to become a family debt also. And so the benefit is there, but it's weighted out now against that debt. What I do find is that, and I'm going to try to say this as bluntly but gently as I can, the parents are generally driving these agreements. And because of the gift, they've got a little schlep in the conversation there in terms of their ability to say, look, to their child, we're going to need to protect this. But where I think that we can make this conversation easier is bringing me in early in this discussion. It doesn't mean I'm writing the agreement. It doesn't mean I'm doing anything besides providing some of this same education. And also to make it, we're not all scumbags as lawyers. and to introduce and put a face to it and really create that comfort for this family that we are part of the team, because you're exactly right that nobody wants to ever have to talk to their family lawyer or any family lawyer. Most of the time it's happening because something has really gone wrong, and we provide a lot of assistance there in helping families navigate through one of life's truly traumatic events. This is the other end of it where we can really help put into place those belts and those suspenders to really help the family as they move to the next generation.
Yeah, this has been wonderful, and we'll cap it off here for today, just for the time's sake of the podcast. Abram, we are going to have you back. We'll do the home and away series. We're only one floor away now. Wayne and I can make the trek.
No, I'm happy to come up here.
Yeah, is there a break for you? Yeah,
exactly.
That's awesome. No, I really appreciate your time. There has been a lot of information here, which I will extend to all the listeners and say, if you have questions, you heard the podcast. For the next episode, maybe even at the beginning, if we just do a rapid fire of some of the questions we got, from a recap from the last one would be a great idea. But going down the rabbit hole, all I can get out of this is it's okay to have proactive conversations about the assets, about the family situation. Like I say, getting someone involved, having that family table, that family discussion, or even to pick your brain apart. So again, Abram Averbach, partner at Scott Venturo Rudikoff. We will have your information in the podcast link on the bio. Otherwise, of course, you can reach out to Wayne and I. But a lot of takeaways. We can look, we can assess the situation. We can compartmentalize it to certain areas from what I understand. Doesn't have to be all or nothing, as you say, but we can field every questions. Thanks for joining the Cresco Wealthcast. Wayne, thank you as well. And I'm looking forward to the next ones. And would be helpful, maybe even just the direction, the natural progression to give to our listeners to say, yeah, is it the trusts next? Is it that we'll take your advice on that for sure.
Well, and thanks very much. I've really enjoyed this as well, and this has been a pleasure. And I'm looking forward to the next ones, and we can start getting into a little bit tighter, a little more substance in each one in a more directed area. But yeah. I've really enjoyed this, so thank you so much for having me.
Likewise, thank you. Hope you enjoyed the episode, everyone. Thanks for stopping by. Please feel free to leave your comments, or even if you want to let me know topics that you think I should be talking about. You can find us on LinkedIn, Facebook, Instagram, and YouTube. Just search at Cresco Wealth Management. And last but not least, if you want to be up to date with our newsletters, our insights, and even our events that we host throughout the year, you can reach out to me directly. It's pretty simple. You could just go to our website, find me from there, crescowealthmanagement.com. Thanks again, everyone.